Hi there, I'm Jim Zirin. Welcome back for more conversations. With us is Bob Pigott. Bob Pigott is a top-notch New York lawyer with an eye for history. His focus has been on the dozens of buildings and structures that represent our city's rich legal heritage, ranging from the Beaux-Arts Surrogates Court building on Chambers Street, built in 1907, to the old federal courthouse on Montague Street in Brooklyn Heights, where the Eastern District of New York first found a home in 1867. His illustrated book, New York's Legal Landmarks, has become a classic. More recently, he's turned his attention to some of New York's legal lions, the all-but-forgotten lawyer-statesmen who earned a special place on the national scene. I'm pleased to welcome Bob Pigott back to the program. Well, Bob, I picked up this periodical of legal history known as Judicial Notice, and there was your article on William M. Evarts, a lion of the New York bar. How did you come to be interested in William M. Evarts?
What I like about this story is that it starts with a mystery, not on the order of Charles Foster Kane and Rosebud, but something sort of in the same vein. Over 40 years ago, I went to high school near 2nd Avenue and 14th Street, and I distinctly remember walking by this tenement that had chiseled over the doorway the words U.S. Senate, and that really puzzled me. The U.S. Senate once did convene in New York City in 1789 and 1790, during that brief year when New York was the capital of the United States, but that was down on Wall Street, and at that time, 2nd Avenue and 14th Street was farmland. What I didn't notice was that the next tenement over had the words W.M. Evarts chiseled over the doorway, and that really is the clue to why these tenements were so named. This fellow Evarts, William Maxwell Evarts, was a U.S. senator in the late 19th century.
Did he live in one of the two tenements?
Well, he didn't live in one of the two tenements. He had a really grand mansion on the site of the two tenements. He was there from about 1850 to 1900, at a time when 2nd Avenue was still a fashionable place where a very successful lawyer might live. But after his death, the tenements were his mansion was torn down, and the two tenements were built. And to remember him, those two names, U.S. Senate and W.M. Evarts, were carved in the two doorways. So that's the connection. But as I started...
Okay, so you got interested in the man because of two buildings and his name on one of the two buildings. Now, tell us about the man. What did you find out about him?
Well, this is really extraordinary because this man, William Maxwell Evarts, is completely forgotten. There isn't a park or a statue or a high school name for him, but he was the most successful lawyer of his era in New York City, but also a phenomenal statesman. He was U.S. Attorney General. He was U.S. Secretary of State. He was a U.S. Senator from New York for 6 years. He represented Andrew Johnson in the impeachment trial in the U.S. Senate against Johnson in 1868. He was Rutherford B. Hayes' counsel in the disputed election proceedings.
Well, Johnson was acquitted, and he promptly appointed Evarts as his Attorney General.
That actually was a career pattern for Evarts. He represented Johnson, and Johnson appointed him to a cabinet. He represented Rutherford B. Hayes, and Rutherford B. Hayes appointed him to his cabinet.
Made him Secretary of State.
That's right.
Nothing like being a successful lawyer.
Yeah.
Or having a grateful client who happens to be the President of the United States.
And this was in addition to a tremendously successful legal career. He really was the preeminent lawyer of his era.
So talk about his career at the bar a little bit.
Well, he came to New York after graduating from Harvard Law School in 1840, went to work for a well-established lawyer, but after only 1 year, struck out on his own and very quickly began building up a very impressive practice. In 1860, he litigated a case that was very similar to the Dred Scott case. It was called the Lemon Slave case, although the result was different. There it was found that a slave, by virtue of being brought to New York State, even if only in transit, gained his freedom.
Well, the Dred Scott case was 1857, and there they held just the opposite. They said, actually, it was a disgraceful opinion, a dark day in the history of the court, because they held that African-American people were not citizens of the United States. So therefore, they didn't lose their status as slaves, even though they went into a free state. Evarts was involved in the 1860 case, the Lemon Slave case, which achieved the opposite result in New York State.
It may have depended on the fact that Dred Scott was brought into a territory which implicated federal legislation governing the right to own slaves in the territories, whereas Lemon had been brought into an existing state of the Union, New York State.
Well, I think it was Charles Evans Hughes who said that Dred Scott was the greatest self-inflicted wound that the Supreme Court ever dealt itself.
Hughes, another great jurist who also had a very rich New York City life as a lawyer.
Well, perhaps we can get to him. So, all right, so he had the Lemon slave case, and what were his other notable cases?
Well, I think the one for which he might be best known is his defense of Henry Ward Beecher in a case brought by a friend of his, Theodore Tilton, for criminal conversation and alienation of affections.
Okay, now a lot of people out there don't know what criminal conversation is, so maybe you can give us an insight into criminal conversation.
Well, these are causes of action that don't exist anymore, thankfully.
They've been abolished by statute. So
That's right.
Alienation of affections, breach of promise to marry, criminal conversation. So tell us what they are.
Well, Theodore Tilton had been first of all, Henry Ward Beecher was perhaps the most famous man of the time. He was the brother of Harriet Beecher Stowe, who wrote Uncle Tom's Cabin.
He was an abolitionist.
He was an abolitionist. He was the preacher at the Plymouth congregation in Brooklyn Heights. And he was so popular that people, at that point in time, Brooklyn was a separate city. It wasn't part of New York, which then was pretty much just Manhattan.
Oh, it's not a separate city today?
Well, some might think it is. But he was so popular that there were Beecher boats, people coming over from Manhattan to Brooklyn to hear him preach.
And he preached against free love, didn't he? He was very moralistic.
That's true. So that's what makes this case all the more poignant.
A sex case. This is a sex case. Come on.
This is a CUNY TV. We can say a sex case. And Tilton was his friend. And it seems
and
clear.
Tilton had a beautiful wife.
He had a beautiful wife, Elizabeth, and it seems clear that Beecher had an affair with Tilton's wife. And initially, it seemed like they patched things up, but gradually Tilton felt compelled to talk about it. And ultimately, after Beecher was cleared by the church, Tilton brought his suit in Brooklyn City Court, which at the time was located in the county courthouse on Jermalaman Street, a wonderful building. Now it's the site of Brooklyn Law School.
The suit was for criminal conversation, that's adultery.
Right.
What we might call adultery, and also alienation of affections.
That's right. And so Beecher retained Evarts, who was the preeminent litigator of his era. And it was a 6-month trial in Brooklyn in 1875. Ultimately, it was a hung jury. The jury deliberated for, I think, 8 days. They had dozens and dozens of votes. The votes varied from 11-1 for no liability to 7-5. Ultimately, it was 9-3. So it was a hung
9-3 for liability.
for no liability.
For no liability.
It was a hung jury. Beecher got off. Was it a vindication? I think most people probably believe that he had, in fact, had an affair with Tilton's wife, but he had been cleared. At least he hadn't been found liable.
So he was not cleared in the court of public opinion. He was just cleared in the court of law.
That's correct.
No, he wasn't really cleared. There was a jury disagreement. There might have been another trial, but there never was. So what did Evarts contribute to this whole thing? You know, there was much reason to believe that that he was Beecher was guilty because the wife, Tilton's wife, confessed it to none other than Elizabeth Cady Stanton, and who in turn told another suffragette feminist, Mrs. Woodhull, who was completely at odds with Evarts.
Right, who was also
and at odds with Beecher.
And she was an advocate of free love,
Yeah.
and she was a great and good friend of Cornelius Vanderbilt, who took her under his wing. She was actually the first woman to run for president of the United States, and she had a brokerage house, really a very unusual woman for her era.
Right. So 2 women knew the secret, but neither one could testify about it. Now, tell about that.
Well, I think, you know, that's at that point, when it was clear that Mrs. Tilton wasn't going to testify, the question was whether...
Well, why didn't Mrs. Tilton testify?
Well, it's because of spousal immunity. And Mr. Tilton...
What's spousal immunity?
It's the right of one spouse to prevent the other spouse from testifying to preserve the sanctity of the marital relationship.
Okay, so Tilton brought the suit, but he couldn't call his wife and ask her whether she'd had an affair with Beecher.
Right. But then the question was, when Evarts was cross-examining Tilton, is it fair to allow Tilton to testify, given that his wife had not been allowed to testify? And ultimately, the result was that Tilton was put on. Everett cross-examined him, but Tilton could not go into any confidential communications he had with his wife.
Like, did you have an affair with Beecher? Yes, I did. He couldn't go into that.
Something like that, yeah.
But he was asked, Everett was kind of clever in his cross-examination. It was later considered to be a masterpiece by legal scholars because he asked him whether he'd noticed any change in the relationship as she became friendlier and friendlier with Beecher, and he said no. That was pretty damaging.
That was very damaging. And interestingly, on the other side, the cross-examination was also viewed as just a textbook case of brilliant cross-examination. Tilton's lawyer, Fullerton, cross-examined Beecher very effectively.
And so you had this inconclusive result in court, and it was all left for the court of public opinion.
That's right.
So what other cases did Everett have?
Well, the representation of Johnson is a singular case. And recently I was flipping the channels and I came upon a movie which is a biopic of Andrew Johnson with Van Heflin as Andrew Johnson in the 1940s. And I thought, great, I'll finally get to see Everett on the screen. But of course, you know, golden age of Hollywood simplification, he's not in the movie at all. In fact, Johnson himself delivers the closing argument that in fact Everett's delivered before the US Senate.
He summed up for
many days.
Many days.
It's hard to imagine that.
That's what he was most brilliant at. It was summing up for long periods of time. It was 8 days in the Tilton case, and I don't know how many days in the Johnson case, which was one of America's two impeachment trials, both of which ended in acquittal.
The few summations I've done, I've barely been able to pad out to more than an hour. And here he is on the...
Well, and also you have a judge who says you're going to be limited to an hour, counsel, a half hour or worse. So any other cases that were notable?
You know, he combined a federal practice with a state law practice. He was also a leading figure in New York City. I was bicycling through Central Park the other day, past Cleopatra's Needle. He was the speaker when that was unveiled.
Speaker at the Statue of Liberty.
He was instrumental in raising funds to build the pedestal, and he spoke there. Also at the 7th Regiment Armory. He was the first.
That's the one on Park Avenue.
Correct. He was the first president of the Bar Association of the City of New York and held that role longer for anyone else, nearly 10 years. Just a remarkable figure, and that's why I think it's so incredible he's completely forgotten. The only time his name still comes up is with respect to something called the Everett's Act, which...
Because he was a United States Senator.
He was the United States Senator.
So we're back to that building you saw when you were in high school.
Right. So when he was in the U.S. Senate, he was the sponsor of a bill that greatly changed the federal court system and gave it the structure we currently know. Before that, there had been this unusual court between the district court and the U.S. Supreme Court called the Circuit Court, and that was essentially abolished by the Everett's Act.
And that created what was then known as the Circuit Courts of Appeal, and now known as the United States Courts of Appeal.
And it did away with a very unusual phenomenon, and that was the responsibility that Supreme Court justices had previously had of riding the circuit, traveling around with a district court judge to try cases. It was quite a burden on the Supreme Court justices, and of course they were very pleased to be relieved of that.
Okay, so you mentioned another legal lion at the New York Bar, Charles Evans Hughes. So tell us something about Charles Evans Hughes. He was famous for saying, as Secretary of State, offended the Japanese, the only way to disarm is to disarm. And it's not a notable quote, but he said it. So tell us more about him.
Well, like Everett, Hughes was not a native New Yorker. He was born in upstate New York. His father was a preacher. He came to New York and went to the firm that became Hughes, Hubbard & Reed, married the boss's daughter, the leading partner's daughter. But actually, after a few years, the pressure of practice got to him, and he quit to become a law professor at Cornell and did that for a year or two. But then he returned, and he gained a reputation as a brilliant litigator. He was tapped to do some investigations of a couple of corrupt industries, the gas industry being one of them. And that led to his being elected governor of the state of New York. And then, on the strength of that, he was appointed as an associate justice of the U.S. Supreme Court. And that's actually something that's very different from today. Today, all of the nominees that I can recall in recent years have a long careers as jurists. They weren't political figures like Earl Warren or Hughes, both of whom had been governors.
Well, you have Elena Kagan, who was not a jurist, had no prior judicial experience, and you had Clarence Thomas, who had very limited judicial experience.
But they hadn't held elected office.
Yes.
They weren't rough and tumble politicians. Hughes was appointed to the Supreme Court. And then I find this incredible. In 1916, now we know that people start campaigning 2 years before an election for the president. And sort of shortly before the Republican convention, he was tapped as the Republican nominee. He didn't campaign at all. He accepted it. And he very nearly beat Woodrow Wilson, who was running for a second term.
Let's move on to another line of the bar, Elihu Root. It's interesting that Elihu Root made the statement that being a lawyer was the only office I ever cared about.
Yep, and this is
even though he'd held high national office as well. So tell us about Root.
Well, Root came to New York from Clinton, New York. His father was a professor at Hamilton College. Root went there and was valedictorian. He came to New York, went to NYU Law School, and began practicing law. And one thing that's interesting is that both Evarts and Root and Hughes all got their starts as litigators. However, by the late 19th century, lawyers were sort of transitioning, and they were taking on a role as transactional lawyers, advisors, as well as litigators. So Evarts really didn't...
Counselors rather than advocates.
That's right. That was a role that Root played. And he was appointed Secretary of War by McKinley. And then when Roosevelt became president upon McKinley's assassination, Roosevelt appointed him Secretary of State. He also won the Nobel Peace Prize for its efforts to promote international arbitration.
Wasn't he one of the authors, if not the principal author, of the open door policy toward China?
That's right. He and John Hay. That's correct.
Yes.
Hay started it and Root continued it.
And he was also, a United States Senator, wasn't he?
That's right. One thing to remember about this is at that time, until I think it was 1917, the U.S. Senate was not an elected position, popularly elected position.
There was no direct election of senators. It was part of the genius of the framers to filter the government from the people. You have the Electoral College and then also in the United States Senate, which was owned by the state legislatures.
So Evarts, Root, they never ran for office in a general election.
Now, as a senator, he was one of the major supporters of the League of Nations, which of course failed, but he certainly was very internationalist in his mindset.
Actually, the failure of the League of Nations reminds me of sort of the appearance of another New York lawyer, and I'm thinking of Woodrow Wilson. A lot of people remember him as having been the president of Princeton University before he was governor of New Jersey and then elected president. But he very briefly practiced law in Virginia. He had a law degree. And after his presidency, when he was devastated by the failure of the League of Nations, he was beset with tremendous physical problems, having suffered a very serious stroke. There was a question of how he would support himself. And a member of his cabinet, Colby, who was a New York City lawyer, got into his head to start a law firm with Wilson. And they created the firm of Wilson and Colby. And if you are to open a volume of Martindale Hubbell, which is the directory for lawyers, and in 1920, you will find this firm, Wilson and Colby, which might suggest that Woodrow Wilson was yet another New York City lawyer who had a great role in government and politics. However, the truth is that Wilson was in such ill health that he never left Washington. He went once or twice to their D.C. office, never set foot in their Nassau Street office. So this Wilson and Colby was really more of a phantom law firm.
So let's discuss another New York lawyer, Franklin Delano Roosevelt. What can you tell us about him that we don't know already?
Well, he had 2 stints as a lawyer, one right out of Columbia Law School when he was a young man. And this I find funny. If you were to go to the library of the law firm Carter Ledyard on Wall Street, they have framed on the wall the offer letter that they made to FDR in 1906. And what I find so funny about it, and only someone with FDR's patrician background could probably accept these terms. There is an offer that says, of course, first of all, it gives him a very generous time to start. I think he didn't have to start till late September or October. But there's the statement, of course you understand that in the first year we can't possibly pay you anything. And if you were to stay a second year, while you might get paid, it will necessarily be a very small amount.
That letter was signed by a lawyer named, partner in the firm, named Edmund L. Bayless. Do we know anything about him?
I actually never had occasion to look into Bayless all that much.
He's not quite so well known as Franklin Delano Roosevelt.
I think that's right. But Roosevelt, of course, had a greater gift for politics than the law. I don't think he ever really committed himself to the law. And very shortly after that, he ran for the Senate in Dutchess County, where his family had their country home, and was elected.
The state Senate.
Right, the state Senate.
So I think it was Oliver Wendell Holmes who said that Roosevelt had a second-rate intellect but a first-rate temperament.
Right, but he was a brilliant politician, and he was appointed Secretary of the Navy. He was a candidate for vice president in 1920, and then, of course, he suffered his stroke.
I think his mother only approved of his foray into politics when he took her to see a ship when he was Secretary of the Navy. I think the ship had been named after her.
His mother also gave Franklin Eleanor a townhouse in the East 60s, but Eleanor wasn't too thrilled when she realized that the mother kept the adjacent townhouse with a connecting door.
Well, no free lunches, always strings attached. So Bill Clinton had said of Franklin Delano Roosevelt that he made public service fun again. You think that's a fair statement?
It is. Even today, when you see old newsreels with FDR addressing the public, or you hear some of his old fireside chats, there's just a naturalness and a humor that I've never heard in any president before that.
And a certain optimism as well.
Which was so necessary at the time, of course.
Yes. Now, Benjamin Cardozo, there's an interesting story. He was the judge of judges. He was a judicial giant. What can you tell us about him? He came from New York, too.
He came from New York, and he really lived in New York City his entire life, except when he was appointed to the Supreme Court towards the end of his life. But, we remember him from first-year law school, Palsgraf, McPherson, these great tort law decisions he handed down when he was on the New York Court of Appeals, ultimately as chief judge.
He was a great judicial writer. Right? That's why Palsgraf and McPherson versus Buick, in which he decided in the Court of Appeals, that's why they live on. And I remember he had said of the suit for unjust enrichment, he said it was a suit whereby the conscience of the chancellor obtains expression. I mean, he had just a marvelous way of writing and a marvelous judicial style, and the many, many examples, probably even better than the assault on the citadel of privity proceeds in this day apace.
Or that description of fiduciary duty in the Ultramarus case, the punctilio of honor.
Yes, that's right. I thought this in Meinhardt v. Salmon.
Yeah, that's right.
In Meinhardt v. Salmon. But
anyway, what's interesting
tell us about his background.
So what's interesting, it seems that what may have driven him was a desire to overcome the disgrace that his father had experienced. His father was a Supreme Court justice and part of the Tammany Hall machine. And when everyone was closing in on Boss Tweed, the father, Albert Cardozo, also resigned in disgrace. He was not disbarred. He was able to preserve his law license, and that allowed him to sort of rebuild his professional life and his family life. So while briefly the family moved to a house in the West 40s, a very unfashionable part of town, ultimately, and the building is still standing, they bought a townhouse on Madison and 68th. You can see it now, although the first floor is it's actually a store for ladies' unmentionables, a very fancy store. But that's where Cardozo grew up. And one thing that's sort of funny is that his tutor, when he was growing up, was Horatio Alger. His was not a rags to riches story, really, but his tutor was Horatio Alger, who wrote all those rags to riches stories.
Do you feel that he was motivated, at least from your study of his life, either in whole or in part, by his father's disgrace?
That seems pretty clear, that he committed his life, a life of absolute rectitude and probity to overcome the disgrace of his father's resignation from the bench. So he was living on Madison Avenue. He would walk down Madison Avenue to Columbia Law School when it was located on Madison and 49th Street. He went into practice with his older brother. He was he was elected to the Supreme Court, and very shortly thereafter was appointed to the Court of Appeals, and he stayed there until his appointment to the U.S. Supreme Court by President Hoover, and that was in the 1930s. I think his state career, his career as a state judge was probably a lot more distinguished than his career as a U.S. Supreme Court justice. He really distinguished him more with his decisions in state law. I think he was unhappy relocating from New York City to Washington, D.C. He never married. He lived with his sister for many years on the Upper West Side in a brownstone just off Central Park West. And he served on the bench for about 7 years until his death in, I think, 1937.
On the Supreme Court bench.
Yeah.
So, unfortunately, we have to wrap up. And this has been just marvelous. And thank you so much for this tour down memory lane of New York monuments and New York legal lions. But what is it about New York that makes it the proving ground for so many great national figures?
Well, I could list another 25 people who were, held high government office and were New York lawyers. But that tradition, and then because New York is the center of the legal world, the financial world, and that's why some of the finest lawyers find themselves in New York City. But it's a tradition that you really don't see as much anymore. And maybe, the confirmation hearings that we see today are a reason why very successful lawyers are less inclined to subject themselves to political life.
Well, Cardozo was approved in the United States Senate unanimously by voice vote. So, Bob Pigott, thank you so much.
Thank you very much,
coming
Jim.
by. And thank you for coming by. Tune in next week for more conversations. I'm Jim Zirin. Take care and all the best.